Well, I'm sure, as you well know, a judge ordered that Trump should relinquish control of the National Guard to the state of California. However, an appeals court delayed that order and blocked Trump's National Guard from being deployed to the state of California, which raises the question, how much authority does a president have over a state's authority? And is Trump pushing that limit? Let's welcome to the show John O'Connor. He's an attorney. He's also author of the book Postgate, How the Washington Post Betrayed Deep Throat, Covered Up Watergate, and began today's partisan advocacy journalism. John, good to have you with us.
Great to be good with you, Rick.
So, how much authority does a president have over a state's authority in instances such as this?
It's clearly limited to certain situations, but I do believe he has authority to do what he did. Under the Militia Act of 1903, which is the whole idea, the president can federalize the National Guard if he is unable to execute the laws. That's one thing, in this case, the immigration laws, or there is a rebellion or a danger of a rebellion against the authority of the United States. So in other words, it doesn't have to be a full-fledged military invasion. It's a rebellion against the authority, like the Whiskey Rebellion of 1790s. That's what it is. So I think, and remember, Eisenhower and Kennedy used this same thing to desegregate the schools, to protect the people that were entering schools where the states would not protect those people. So I think this is perfectly fine. It's the analogy is we're protecting ICE agents from violence and preventing them from doing their duty. So we need these folks to be able to enforce the law. So I think it's proper. And under the statute, the president has the sole and exclusive discretion as to when those prongs of the statute are met. One out of three are met. And I think Trump's done that. Now, I've read the opinion a couple of times. It's a brilliant document, and the judge is a brilliant guy. He's the brother of Stephen Breyer, the Supreme Court judge. So I like this judge. He's a very smart guy, and you would want him in most cases. I think in this case, he's gone very far because I just don't think he agrees with Trump. And so he's doing the best he can to say, no, Trump, you can't do that. I just don't think, as a technical matter, he's made his case. And I suspect our appellate courts, even though they're very liberal and very much democratic, I still think that I think Trump's probably going to prevail on this one, because it's really pretty serious when a judge is telling a president not to do something that involves the armed forces, and the president under the Constitution is the commander-in-chief of those armed forces. I think it's a pretty heavy lift for a district judge to do this. I mean, I admire his intelligence and his writing style, but I don't think I looked at this and I found several different places that I disagree with them very strongly.
What was the main backbone of his disagreements, not disagreement, but of his conclusion that Trump stepped out of bounds on this?
First of all, he says that he has the authority in the first instance to decide whether there's a rebellion or whether the president's unable to execute the laws, whereas the statute seems to leave that to the president. So the judge says, before the president can step in, I get to be the initial guy. That's number one, procedurally.
That sounds true.
The second thing he does is he defines rebellion very narrowly to say it has to be organized, armed, and against the entirety of the government. In other words, if it's not basically a war, like the Civil War, the president can't do this. Whereas we know that a rebellion, and he gave us definitions of a rebellion, but he said, no, the second and third definitions of Black's Law definition of rebellion don't apply. Only the first one, which is the more serious type of rebellion. So therefore, I'm going to say that this is not a rebellion. And number two, I'm going to say, Trump says he can't execute the laws, but I think he can. Just because he's not getting as many arrests as he'd like to have, well, too bad. Tough luck. And by the way, every federal law person can be in danger. That doesn't mean they can't execute the law. So what? I mean, basically saying, so what if a couple of them get killed? So I think his reasoning just is too tendentious. It's too much academically and hair splitting. And so I think the president has the authority under these laws. I don't think a lot of people don't like it, but it's the president's call. That's the point. It's the president's call, and we elected him. And a lot of people here in California don't like the fact that he's elected. They don't like him. They don't like the way he and his uh, administration think about things. I think there's sort of a snobby intelligentsia type of group here that really are very bright people, but just don't like Trump and his ilk.
With that being said, why do you suppose an appeals court is going to come out in favor of Trump, particularly since I think you stated they tend to be quite liberal?
Well, they do, but remember this: the Supreme Court has looking over their shoulder this thing called the appellate court has the Supreme Court looking over their shoulder, and the worst thing you can do as an appellate court judge is to get slapped down by the Supreme Court and say, "Did you guys read the words in this statute? You can't be serious here." So, also, I think the appellate court is more isolated from the madding crowd, so to speak. I think. Judge Breyer is very involved in San Francisco and San Francisco politics and so forth. His family always has been. He's a good guy, and I think there's probably he's doing a solid for his team here, and I think he really believes that this was an unnecessary calling out of the guard, but I don't think it's his call. That's the difference. He says it's wrong, but the law says it's Trump's call. So that really gets down to it. But I do think the appellate court it is pretty serious when a judge says to the president, you can't, I'm going to interfere with your use of the military. That's really extreme. One thing the president should do and is in charge of is the military. He can call people to Vietnam without a declared war. He can call people to Korea without a declared war. He can put down the Whiskey Rebellion in 1790s without declaring a war. The president has national security powers that are very, very strong and within his own discretion. So I think this is one element of the Constitution that the people in the appellate courts are saying, whoa, we better look at this before we're going to let this go. Now, they may end up upholding the lower court, but I think they want a serious look at this. And it may well be one of these things. Sometimes the courts decide something what they call en banc. Sometimes it'll just be three judges, but sometimes they'll say, okay, the whole Ninth Circuit gets to decide this. This is a serious issue, Rick. And I think we haven't heard the end of it. I think this is a very, very important issue. It's the most crucial issue of Trump's presidency, I'd say, from a legal standpoint.
John O'Connor, good information. I mean, you explained it so well as to why what has happened, and why you think the next step will occur as in Trump's favor. In less than 30 seconds, let me ask you, why is it so bad for a appeals court to be overturned by the Supreme Court?
Well, it's just a slap in the face. And one of the ways the Ninth Circuit has been criticized in the past is people say, this is a terrible court because the Supreme Court has knocked them down so much. And I think they do have the record for being knocked down by the Supreme Court the most. And it just makes you look like you're a hack. People wear those robes for honor. They're not making money. They could make a lot more money in private practice. All of them are pretty brilliant, accomplished lawyers. And they do it for their legacy and for their reputation and for their honor. Those are the driving principles. And I think if they're going to stick their neck out in favor of civil rights, that's one thing. They can say, "Gee whiz, I was slapped down, but I did it in the right in favor of civil rights." But here, you might look like you're something of a bad judge. History books may not treat you kindly if you're going to say ICE agents should get the hell kicked out of them, and we can't do anything about it. That's a pretty rough burden to carry. And remember, Rick, let me give you an idea. Back when George Bush sat back and said, "Oh, the state won't let me federalize they object to me federalizing the troops in Hurricane Katrina. I'm not going to do it." He got widely criticized for that. It almost destroyed his presidency if it didn't dent it quite a bit. And I think he finally did call up the guard, but much too late. And he was criticized for that. And remember, Eisenhower and Kennedy called in the guard for desegregation purposes. So I think this is something that will go down in the history books as a big deal.
John O'Connor, attorney, authored a book, Postgate, How the Washington Post Betrayed Deep Throat, Covered Up Watergate, and began today's partisan advocacy journalism. I thank you for joining us, and you've put a lot of great information and context into what's happening in this particular story. Thank you.
Thanks, Rick. Good talking to you.
Back with more after this.